Hi everyone and welcome to today's PQSL. We're just going to give it a minute or two to let everybody join. Okay, we have a good few in the call now this morning, so we're just going to kick off. So hello everyone and welcome to today's PQSL on Landlord and Tenant. So within today's session, we will look at a typical rent review process, arbitration, key legislation, what to look out for in a lease and general commercial lease analysis. And today's PQSL will be presented by Ian McLaughlin. So Ian McLaughlin has worked in professional services and has been working for CBRE for 9 years. Ian's main focus is on landlord and tenant issues with an emphasis on rent reviews and lease renewals for commercial property. Commercial lease analysis is a key function of his role. Ian has in-depth experience representing both landlords and tenants in lease consultancy matters and has also acted as an expert in both arbitration hearings and court hearings. So without further ado, I'm going to hand you over to Ian.
Hi everyone, thank you for coming along to this PQSL on landlord and tenant, with a particular emphasis on the rent review process in Ireland. As Grace has pointed out, my name is Ian McLaughlin and I've worked in CBRE now for almost 10 years. I act on behalf of landlords and tenants, specialising in the negotiation of rent reviews, lease renewals, lease regears. I also represent my clients in third-party proceedings. And other services that I advise on include lease consultancy, drafting of new leases, interpretation of lease provisions. So we'll kick off with an overview of what I will cover today. So at a very high level, I will go through a number of slides on specific topics, which I'll outline now. And then at the very end, we'll go through some typical questions that might be asked in an APC scenario at interview. So what we'll cover today, what is a rent review? Skills required to be a rent review surveyor. Different types of rent review. Stages of a rent review, so that includes preparing for a rent review. Valuation considerations. Arbitration and dispute resolution, the process behind that and what's involved. Standard and non-standard rent review provisions that you might find in a lease. Key legislation. And then we'll finish off with some potential APC interview questions and some answers there if we have time. So I guess first and foremost, what is a rent review? So rent review clauses, they're a feature of almost every modern commercial lease, which is granted for a term of any significant length. The general purpose of such a clause is generally described as enabling the landlord or tenant to obtain from time to time the market rental, which the premises would command if let on the same terms in the open market at the review date. Ultimately, the purpose is that the reviewed rent will be a reflection of the changing value of the demised premises during the term of any lease, any commercial lease. So what skills are required to be a rent review surveyor? Typically, negotiations around rent reviews are quite specialist and they require a blend of certain skills. And within that skill set, knowledge of the implications of the terms outlined in any lease, an insight into the fallback dispute resolution or arbitration process and whether such an option should be considered following the negotiation process. Local office market knowledge, that can be local industrial, it can be retail, it depends on what you're actually reviewing. Trends, upcoming lettings, and how the evidence compares with the subject rent review. You must also make sure that you're appropriately valuing the property considering the contract terms and the market evidence. And it's important to have an understanding in any negotiation of the other party's positions in terms of the relevance of any issues that they might raise during the course of a negotiation. That can have an impact on how your negotiation goes and whether you end up a third party or not. So there are actually different types of ways that rents are or can be reviewed. The most common is a review to the open market rent. Over the years, different kinds of rent review clauses have been used in leases. But there are also different types of ways of actually amending the rent at particular fixed dates in a lease. So they would include fixed increases. So like things like a stepped rent. Sometimes the parties agree a series of identified step rents within a lease, which provide for a very basic and simple form of rent review. For example, the landlord and tenant might agree to a 10-year lease with a fixed increase in year 5 and no rent review. This may be done for any number of reasons at the start of a lease. Maybe both parties are foregoing the benefits or pitfalls of future market forces in order to secure certainty over the tenure of the lease, rent certainty over the tenure of the lease. While this is seen from time to time, it is not necessarily a common occurrence. The next one would be turnover rents. This is more typically seen in the likes of a retail, a pub, or a hotel type environment. The parties may agree that the rent be linked to the turnover of the tenant's business that's carried out on the premises. And there might be a base rent in there by which the rent may not fall below. If the business prospers, then the rent will increase and the landlord will benefit from that. And if the business doesn't, well, the landlord still receives a base rent. The next one would be indexation. So typically this is known as a CPI rent review. The parties may agree that the rent is linked to an index which records changes in the value of money, such as the consumer price index. The method of calculating the CPI-linked rent reviews varies from lease to lease. Each lease will or should outline the method of calculation. The clearer this is, the easier it is, and the less likely there is to be any dispute over it. So it's very important that the drafting is done correct. So yeah, it could be the change in the CPI over a 5-year cycle. Comparing, let's say, 2019, a rent in 2019 with a rent in 2024, and applying that change to the rent based on any changes in the CPI index. An alternative to that would be that this could be established by year to year and compounded over a 5-year cycle, let's say. There can be other variations depending on the agreement between the parties. Indeed, there can be variations on the type of index to be used as well, but typically in Ireland anyway, we would use the CPI index. So it all depends on what's outlined in the lease, and the clearer the wording is, like I said, the better for all involved. As poorly constructed rent review clauses can create ambiguity and uncertainty and make negotiations or agreements more difficult. The next one would be, I felt it was important to put this in here, and this section would be an upwards only rent review. So as most people would be aware, prior to 2010, commercial leases included an upwards only clause, which meant that the rent could not drop below what it was on the review date. In essence, this meant that even if the market value deemed a rental below what a tenant was paying in rent, this could not be adjusted downwards. However, since the enactment of Section 132 of the Land and Conveyancing Law Reform Act 2009, upwards only rent reviews are now prohibited in all leases created after the 28th of February 2010. Therefore, parties may agree to a lower or higher rent, known as an upwards and downwards rent review, or remain at the same level, depending on a review of market conditions and what's going on at that time. As I'd mentioned before, an open market rent review is kind of the standard rent review in most cases. Open market rent review means that the rent is adjusted upwards or downwards to reflect the rent the landlord, or I suppose the tenant, could achieve on a letting in the open market at the review date. This this is, I suppose, the conventional form of rent review clause. At regular intervals, typically no greater than 5 years, but sometimes less, and the odd time, maybe at year 7 or 10, the rent is reviewed to that which would be attained if the property was then let in the open market on a specified basis. So I suppose next I'm going to just talk you through the typical rent review instruction from start to finish, which can be helpful in terms of understanding the process, and can be helpful for your APC and things like that. So you've been contacted by a client, you've been asked to represent them in the rent review, and I suppose the next steps in terms of preparing for that are the instruction element of it. So carry out your conflict check, agree your fee, get your signed letter of engagement, and request all lease documents. Next, you've got to carry out your own due diligence. So this is where you start to provide your advice to your client once you've been instructed. This will typically involve reviewing the lease documents, any side letters, supplemental agreements, or any other, deeds of renunciation, any other documents that might be relevant. You need to then go and inspect the property, familiarize yourself with what you're actually valuing and what you're negotiating a rent for. And once you've done that, you need to assess all the information that you've gathered, including comparable evidence, and provide advice to your client. I'll go into the valuation considerations in another slide a little bit further down the line. I suppose the next step after you've done all that is to initiate the rent review. I suppose typically a notice is served upon the other party. Usually this is done by the landlord. The details of how this is to be served is contained within the lease itself. In terms of proposals then, the proposal is usually issued again by the landlord. It can be requested by a tenant. It can even be, initiated in that way. A proposal can be sent by a tenant, but typically it's a landlord who will issue the rent review notice and the proposal of revised rent. But again, how this is done is normally outlined in the lease, and we always say always revert back to the lease. The next step is the negotiation phase. So this is, I suppose, an assessment of the proposals, counter proposals that are put back and forth between the parties. You'll discuss the key factors that will impact on the rent review in order to try and agree a revised rent between the parties amicably. If the parties manage to reach an agreement, this is normally documented by way of a rent review memorandum, which is then signed by both parties. A memorandum is a legal document and is normally appended to the lease, I suppose, to document the fact that the rent has changed. If an agreement can't be reached, the lease will usually outline a mechanism for what to do next. Typically, this is the matter is then referred to arbitration. There will normally be an oral hearing or written submissions on the preference of both parties involved, unless specifically referred to in the lease. Once this process is concluded, an award is issued by an arbitrator, and that award is typically final. If there are any conditions for a dispute of the award, they may be referred to the court by either party on appeal. I'll go into that a little bit more in a little bit more detail later, but it doesn't happen very often. And generally speaking, I think the courts don't look kindly upon arbitration awards being referred to them. So valuation considerations. When providing advice, there's a number of valuation considerations you'll need to take into account. The first one for me is a rent review is a hypothetical situation. So rent review clauses normally require a determination of what would be payable by a willing tenant to a willing lessor on a hypothetical letting in the open market. The hypothesis of an open market letting requires it to be assumed that there would be a willing lessor and a willing lessee. The willing lessor and lessee and that the willing lessor and lessee do not possess attributes of the actual lessor and lessee, which is a bit of a mouthful. Once that has been understood, the next focus is on other considerations around the valuation of the property involved. So you're going to look at things like the market at the review date. What's happening in the wider economy, vacancy levels, what is the sentiment like in the market? Is it positive? Is it negative? That's probably what you're going to be looking at on a broader sense of the market. The property to be reviewed, is it a new building? First generation, second generation, third generation? Is it of good quality? Is it a modern or period type building? What is it you're actually reviewing here? The location, depending on what type of asset you're reviewing. Let's say it's an office. Is it a prime city center location? Is it peripheral? Is it suburban? All of those factors are quite important. Next is the demise premises. So what are we dealing with here in terms of fit out, quality of space? Are we to review the premises to a Cat A specification, a tenant enhanced Cat B type specification? Are we dealing with a shell and core premises? Is it part fitted, fully fitted? Fitted but inferior to a modern comparable premises? There's lots of different scenarios that could come up in terms of the quality of the space that has to be reviewed. Next, and one of the most important things is the lease. What are the key lease provisions that are going to impact on the rent review? Are there any particular clauses that are unusual in the rent review schedule that need to be considered? Has the tenant got any break options coming up? Are they included in the assumed term, or are they personal to the tenant? I'll go into that in a little bit more detail later as well. Outside of the rent review schedule, you might consider other parts of the lease, such as the yield up clause, alienation clauses, repair clauses, schedule of conditions, among other items. And then I suppose most importantly, you've got to look at the comparable evidence. So you're looking for comparable evidence that shares the same characteristics as whatever it is you're valuing, whether that's an industrial unit, an office, a retail unit, whatever, to ensure that you're trying to compare like with like. You're going to look at, if you find that kind of evidence, you're going to look at timing. How close is that evidence to the review date? Is it of a similar size? Is the condition comparable? What kind of fit out is in that evidence? Does it have shower, like if it's an office, does it have shower facilities? And does it not? And more recently, I suppose we're seeing more reference towards building BER certs, and they are starting to have an impact on rent reviews. What's important within the context of comparable evidence is the hierarchy of evidence. So the best evidence to rely on is open market letting evidence in the first instance. However, if there's a scarcity of it, then you have to look at alternatives to guide you. The hierarchy of evidence at any rent review is firstly open market lettings between unconnected parties. Secondly, it's evidence from lease renewal negotiations. Then you're down to rent review settlements. Then it's court and arbitration and independent expert awards. Finally, there is hearsay as well, which can be considered further down the hierarchy chain. But it's very hard to attach much weight to hearsay, but I have seen it. Then next would be net effective rents. Okay, so typically rent reviews are carried out on a net effective basis unless there's anything to suggest otherwise. So what I might do now is flip over to the next slide, and we might just go through a very high level of how to calculate a net effective rent. So the reason I bring this up is because with other APC candidates, I've seen this as a question that I've been asked before, and so there's no harm in going over it. So net effective rents, they refer to the actual amount of rent that a tenant pays for a commercial property after factoring in any concessions or incentives provided by the landlord. Net effective rents, they take into account any rent-free periods, tenant improvements, allowances, or other financial incentives offered to a tenant. So for example, if the advertised rent for a commercial property on a lease of, let's say, 5 years is €50 a foot, this would be an office premises typically, the landlord would normally provide a rent-free period. Let's say it's 3 months. The net effective rent for that over 5 years is calculated at €47.50 per square foot. So in essence, this is the actual cost to the tenant over a fixed period of time. And this is calculated as follows. So what is the total amount of headline rent over 5 years? So in this case, it's €50 per square foot multiplied by 5-year fixed term equals €250. You can do this on a rent per annum basis. I just find it quicker and more straightforward to analyze it this way on a rent per square foot basis. What does 3 months rent free equate to? So that's €50 divided by 12 months and multiplied by 3. So that'll be €4.17 per square foot. Next, your actual outlay if 3 months rent free is applied to the total headline rent over 5 years. I hope you can stay with me with this. So that's €250 minus 417, which equals 237.50. So that's the actual amount of money that the tenant will spend over the next 5 years if granted a 3-month rent-free period. If the total outlay for the tenant was divided by 5 to see the annual outlay, you end up at 47.50 a foot. So that would be a standard example of how to calculate net effective rents. I tend to calculate them over the fixed term. Some people like to do it over, say, 10 years or up to the next review date. I think generally speaking, the process that I see followed most is over a fixed term. So arbitration and dispute resolution. So this is the third-party process. What is the surveyor's role? So a surveyor will act as an advocate for their client. Always, when you're advising your client on the third-party process, always refer to the lease. But usually, either party can initiate the rent review or write to the Society of Chartered Surveyors regarding an application to appoint an arbitrator. Typically, there's an application fee of €500 to the SCSI to appoint an arbitrator. In terms of a timeline, it takes about 4 weeks to get an arbitrator appointed if all is going according to plan. Once appointed, you as the surveyor will be notified and the arbitrator will issue their order of instructions. The order of instructions usually outlines the timeline for the rent review arbitration to include submissions, which is normally around 2 weeks, oral hearings that can be 2 to 4 weeks, and an award if all is going according to plan will be 4 to 6 weeks after that. So overall, an arbitration process, this is completely after the negotiation process. Overall, the process is likely to take 3 to 4 months from start to finish. In terms of the mechanics of that arbitration process, usually this is done in 2 ways. It's written submissions only, or it's an oral hearing. On completion of an arbitration, the arbitrator issues their award of new rent. Of course, before they do that, they have to have received their fees from both parties. The award the award documents the final rent that's been I suppose concluded by the arbitrator, and it represents proof of the revised rent until the next rent review or lease expiry, whether that's in 5 years' time or 3 years' time, whatever it might be. Typically, a court will not look kindly, as I said, upon appeal of an arbitrator's award. However, there are 3 kind of broad situations where the court may become involved in the process of a rent review. The first is where the machinery of the clause in the lease is in some way defective, and the court is asked to rectify the clause or otherwise to cure that defect. Second is where the meaning of the clause is uncertain or disputed, and the parties go to court asking for a ruling on what that actual clause means. And the third is where after the conclusion of the rent review, one party is dissatisfied and seeks relief from the court. Such an appeal on a point of law under the Arbitration Act is in order to try and set aside an award. An APC question that sometimes comes up, or it certainly comes up in the preparation, is what are the main differences between the roles of an arbitrator and an independent expert? I I suppose an arbitrator is governed by the Arbitration Acts. Independent experts, they're governed by common law. Arbitrators, they can only make decisions based on the submissions, other party submissions, whatever is presented to them. They can't go rogue and come up with their own conclusions. Whereas an independent expert, they're not limited to party submissions. They can carry out their own investigations, use their own expert judgments, experience in the market to make their award. Arbitrators, they have discretion on costs and lease, whereas experts are guided by the lease itself. And I suppose finally, an arbitrator can make an order for discovery, whereas an independent expert, discovery is not within their power. So back to the lease, I'm going to go through some kind of standard and non-standard rent review provisions that you might come across in the rent review schedule. I'll just go through 3 or 4 of the standard ones to start with. So the first one would be good repair order and condition. So the lease will outline that we are to assume that the demised premises or building or any part of that building, if they've been destroyed or damaged, that they've been fully rebuilt and reinstated. Ultimately, what these provisions are trying to do is limit the amount of arguments or disagreements in terms of trying to agree what the market rent is. So that's why these clauses are considered standard and why they're in there. They've been tried and tested over time. The next one would be a disregard of the current tenant. So you're disregarding any effect on rent of the fact that the existing tenant or any subtenant that might be in there or their predecessors in title have been in occupation of the demised premises. You're also disregarding any goodwill attached to premises by reason of the business then carried out at the demised premises by the tenant or any permitted under tenant. So I suppose what that's saying is that just because a business might be thriving there doesn't mean that they need to pay an above market rent reflective of that. Next is that all covenants are adhered to. So you're assuming that all covenants on the part of the landlord and the tenant contained in the lease have been fully performed and observed. So you're assuming that all things are equal, and you're trying to take out the fact that a tenant might say, oh well, I've got a leak in the building now and I'm not paying X amount of rent, increased rent because of that. They're in some ways they're relevant, but they're immaterial in a lot of ways. And I suppose these clauses are there to try to mitigate the amount of grievances that either party might have. And finally, then a disregard of current tenant work. So again, this is about the tenant not being penalized for improving the space to a stage where you're looking at that space and saying, well, this is really good space, this is modern space, it has a fit out in it, and you're going to pay a premium for that. So the clause here is that you're to assume that no work has been carried out to the demised premises by the tenant, any under tenant or their respective predecessors in title, during which has diminished the rental value of the demised premises. Another one actually that I didn't mention here is that time is not of the essence. So that's one that comes up a lot as a query, but it's a fairly standard clause, and it means that the rent review can retrospectively be initiated at any time. So if it said time is of the essence, that means that there's probably something specific in the lease that's going to say to you that you have to have this rent review resolved by such and such a date. But typically they will say time is not of the essence, which means that a landlord could go back 5 years, 10 years, whatever it might be in the lease, retrospectively to initiate that rent review. Sometimes that's used as leverage to improve their outcome at the current rent review if they didn't initiate the one before that. So examples of non-standard provisions. So what to look out for in a lease here. Breaks and whether they're personal to the tenant or not. Does the tenant have a break in their lease? If so, is the break personal to that tenant? It's very easy to miss that when you're first looking through leases. If it is personal to the tenant and it's clearly specifies that, a break cannot be incorporated into the hypothetical lease at rent review. If there's no reference to the break being personal, then usually it can be incorporated into the lease. it will be settled law that break options which are personal to the tenant are not available to the hypothetical tenant at rent review is pretty much what that means. So in terms of importations of break clauses into a hypothetical lease, a break clause will usually have been inserted into the lease to suit either the personal circumstance of the landlord, in terms of, accommodating a possible redevelopment in a few years, or for the tenant, to allow them the flexibility to, relocate their business in 5 years' time if they don't know what's going on in the world. Those personal requirements or wishes, they'll have little relevance to the needs of the hypothetical landlord and tenant. And as I mentioned earlier, rent reviews are hypothetical situations. And therefore, it is not always obvious that the parties intended the break clause that was agreed at the start of the lease to be incorporated into the actual hypothetical lease. The typical rent review clause will stipulate that the hypothetical lease will be on the same terms as the actual lease, subject to various assumptions in this regards. This formula may result in the break clause being imported into that notional lease. If the break clause in the lease is expressed to operate by reference to anniversaries of the term, then usually this will translate readily into the hypothetical lease. By contrast, if the break clause is expressed to operate on a specified date, it becomes more difficult to contend that the stipulation must be written so as to substitute the later dates in the term of the equivalent length. So that's just something to watch out for. The next one is a headline rent. So market leases are typically silent in relation to the assessment of rent-free periods when establishing a revised rent in a rent review. In assessing comparable transactions for the purpose of rent review, rent-free periods generally get discounted from a headline rent level, like I went through before, to establish the effective rent. When the rent is determined on the assumption of a letting with vacant possession, the rent is likely to be discounted because a tenant would need time to fit out or sublet the premises, depending on what their plans are. And usually rent-free periods are granted to reflect the time and cost of fit out and also to inflate the headline rent. The headline rent clause is to be construed as preventing any discount for the fitted out element of the rent-free, but it does not prevent adjustments of comparables to reflect inducements. So according to this principle, not all rent-free periods should be discounted from the comparable rents when assessing the real or effective rent level. Only rent-free periods over and above the reasonable time it takes a tenant to fit out the property initially should be discounted. So that's really referring to the inducement element of the rent-free period. There's case law on this. I won't go into that in any particular detail today. The Court of Appeal heard 4 cases together concerning the correct construction of a headline rent clause. And I've outlined the cases there. You can take them down or you can probably do some research yourself if you want to look into them in more detail. A headline rent is generally a landlord favorable clause. The high prominence of the 4 Court of Appeal cases referred to above highlights the dangers of such headline rent assumptions. For leases where the wording will be held to produce a headline rent, a valuation argument is developed to mitigate the harshness of such an assumption, namely that its onerous nature would be reflected in a lower initial rental bid from the tenant. The argument is that although the tenant is deemed to have received normal market inducements at the date of the grant of a lease, which is, in this case is the rent review date, and thus they'd be willing to pay a headline rent. But they will be aware that on receipt of a draft lease that they'll be penalised at future rent reviews, if indeed there are any. So in order to reflect this future penalty, the initial rental bid may be reduced. So it's basically trying to look into the future. Just go back there slightly. The condition of the premises is the last one I just wanted to touch on. So this can be a contentious part of any rent review discussion. You've got usually this will refer to something like there could be a schedule of condition in the lease. Depending on the nature of the rent review schedule, there may be some negotiation around the quality or the standard to which the premises are being delivered to the tenant, including the level of fitting out. And this is where the likes of the schedule of condition comes in, because usually there'll be some sort of photographic survey attached to that, which is indicative of how the premises was taken in the first instance. Another way of having some sort of non-standard clause in terms of fit outs would be to have some sort of clearly stated assumed condition specified in the lease provisions or the rent review provisions. We are to assume that the premises is provided in a Cat B quality standard and has a BER of A3, etc., etc., etc. So all of a sudden, we have been asked to value this with clear and unambiguous specifications. And then I suppose general specifications, in a rent review, it could be, if it's not specified, otherwise it could be a Cat A specification that we're valuing, let's say in an office premises. It could be Cat B tenant enhanced. As I said, the condition should be outlined in the schedule of condition or clearly stated within the provisions. If you're looking at a retail premises or maybe some industrial ones, it might be shell and core is what you have to assume. So moving on to key legislation. So there's the key legislation that impacts rent reviews mostly for commercial premises in Ireland is the Landlord and Tenant Amendment Act in 1980 and the Land and Conveyancing Law Reform Act of 2009. So I'll just quickly go through the Land and Conveyancing Law Reform Act first. The Land and Conveyancing Law Reform Act 2009 is a significant piece of legislation that impacts the rent review process for commercial premises in Ireland. This act introduced various changes to the legal framework governing commercial leases, including provisions relating to rent reviews. So I guess the main thing that was introduced here, the significant change, as much as it's impacted on leases generally, is the introduction or the rendering ineffective of upwards only rent review clauses in leases entered into after the 28th of February 2010. So that's one of the key parts of the the Land and Conveyancing Law Reform Act. So prior to 2010, commercial leases, including an upwards only clause, meant that the rent could not drop below what it was on the date of review. Since the enactment of Section 132, I suppose upward only rent reviews are prohibited in law and in all leases, and therefore parties may agree to a lower or higher rent or remain at the same level depending on a review of market conditions. Next, I will just go into a bit of detail on the Landlord and Tenant Amendment Act 1980. The rent review process for commercial properties is typically governed by the terms of the lease agreements between the landlord and the tenant. This act sets out certain requirements and procedures that both parties must follow during a rent review, a lease renewal process, and other elements too. So some of the main provisions in the legislation that relates to rights of renewal would be referring to the likes of a tenement. So every tenant seeking to claim the right to a new tenancy must prove that the premises that is occupied is a tenement, as that term of tenement is defined within Section 5 of the Act. The next is business equity. So Section 13 of the Act provides for the business equity, which entitles commercial tenants in certain circumstances to a new long lease at the end of their existing 5-year continuous occupation of the premises. Usually that's between business equity, long possession equity, that can be 5 to 20 years. Section 13 of the Act also provides for the long possession equity if the premises have been continuously occupied by the tenant, including predecessors in title, for a period of 20 years or more. Improvements equity. Section 13 of the Act also provides for the improvements equity, which I guess this is the test for establishing if the improvements equity arises in the tenant's favor, is less straightforward than for the other two equities. Essentially, it involves the tenant establishing that it is entitled to compensation for the improvements that they've made to the premises, and the value of those improvements is 50% or more of the letting value of the premises at the time that the tenant gives notice of its intention to claim relief. So tenants' entitlements, what are they? Where the tenant can establish one or more of those 3 equities described above, The tenant is entitled to claim a new tenancy beginning from the end of their previous tenancy. It's up to the landlord and tenant to agree the terms of the new tenancy. If they can't agree it, then the tenant has an entitlement to apply to court to recognise and enforce their entitlement to a fixed term or their rights to a new tenancy. There are restrictions in terms of the right to a new tenancy. That's outlined in section 17 of the Act. Some of those would be that the tenancy has been terminated for non-payment of rent. The tenancy has been terminated for breach of covenants by the tenant. The landlord is given notice to quit to the tenant for good and sufficient reason. That would be just some of the ones in particular that you could refer to. And finally, on this section, before I go into a recap and some questions, is the deed of renunciation. So the right to a new tenancy can arise in a number of different ways in a commercial context. The most frequent is on foot of 5 years of continuous occupation, as I'd mentioned, for a business premises. The introduction of the business equity gave rise to the introduction of the 4-year, 9-month lease as a workaround to the operations of the legislation. However, reliefs provided by the legislation still operate in tenants' favour in many circumstances and should be borne in mind as well. Also, often tenants are asked to sign a deed of renunciation, a legal acknowledgement by the tenant that even if the tenant remains in occupation for 5 years or more, they will not automatically be entitled to a new long lease. The tenant needs to obtain independent legal advice before signing a renunciation, and for doing so, sometimes tenants, I suppose, are incentivized to do so by getting rent-free periods granted to them. So I thought I'd just go through before, if there are any questions at the end. Before I do that, I just thought I'd go through some potential questions that might come up in, let's say, an APC scenario as might relate to today's PQSL. And then after that, if there is any time, I can answer any questions if there is any. So potential questions. What is a rent review? To enable a rent review is there to enable a landlord or tenant to obtain from time to time the market rent, which the premises would command if let on the same terms and conditions in the open market at the review date. What dictates a rent review? Generally speaking, it's the lease provisions, the market evidence, the wider economy, what's going on in terms of sentiment in the market. What are typical provisions in a rent review schedule? So at a very high level, that's your assumptions and disregards, which I went through some of the standard and non-standard ones there. Your assumed term, which would include things like incorporation of breaks or not, and third-party directions. Can you name one or two of the standard assumptions and disregards? So again, I've covered that above. You know, could be anything like assume that the demised premises or building or any part of the building have been destroyed or damaged, that they've been fully rebuilt and reinstated, or disregard any goodwill attached to the demised premises by reason of the occupation of the current tenant. What was the last piece of major legislation to impact on rent reviews, or what was a piece of legislation, major legislation to impact on rent reviews? So that would be the likes of Section 132 of the Land and Conveyancing Law Reform Act 2009, and in particular, upwards only rent reviews and their treatment. Can you take me through a rent review process from start to finish? So you've been instructed, what next? So I went through that as well. Instruction, advice, initiating the rent review, negotiating, trying to agree a rent, signing that off by way of memorandum. If you can't agree a rent, you're going to the third party, which can be done by way of written submissions or oral hearings, and then you get a final award. What are the factors to consider in arriving at your opinion of rent? So this is your valuation consideration. So you're going to consider the market, the property, the location, the demised premises, lease, comparable evidence, where that comparable evidence fits into the hierarchy of evidence, and typically net effective rents. What happens if the parties can't agree a rent? So like I said already, what does the lease say? That's the first thing you do, refer to the lease. Is it arbitration? Is it expert? Is it court, mediation? Typically it is arbitration an expert or arbitration scenario. Last few on this. So is there any appeals process for an arbitration arbitration award? Yes, it's not looked kindly upon, but there are opportunities to do that. There are three situations in particular. There's an issue with the machinery of the clause in the lease and it's some way defective. The meaning of a clause in the lease is uncertain or disputed, or an appeal on a point of law. Difference between an independent expert and an arbitrator. So what are the main differences between those two roles? I covered that in detail above. Are you aware of any case law relating to rent reviews? So you can refer to the 3 or 4 cases I've referred to in the headline rent section, and the likes of the Broadgate case, but one which I didn't go into today is one you can Google yourselves. It's the Bewley's case. It relates to a challenge by Bewley's back, I think, in 2014 on upwards only rent reviews. It was initially upheld by the High Court, the Bewley's challenged this, but later overturned by the Supreme Court. So it's an interesting one to read if you are inclined. And then finally, what is a tenant not entitled to? When is a tenant not entitled to a new lease? So like I mentioned before, non-payment of rent, breach of covenant, the tenant terminates the tenancy, the landlord is given good and sufficient reason to via notice to quit to get back the premises. So that is it. Thank you for listening today, and if you have any questions, I'd be happy to ask them or answer them.
Brilliant. Thank you so much, Ian, for a fantastic presentation. There are some questions that have come in, so I'm just going to read them out to you. So the first one is, are rent reviews and lease renewals covered by the PSRA? For example, do you need a PSRA engagement letter signed when offering these services?
No, I don't believe so. I don't need to be, for example, I don't need to have a PRSA card, and our engagement letters wouldn't include that side of things. So no, as far as I know.
Perfect. Another question is, if there is a fit out percentage between tenant and landlord, say 80% for tenant, 20% for landlord, would this affect the rent review as landlord has undertaken partial fit out / upgrade works to the units? If so, would this be calculated?
That's probably convoluting things a lot, but yeah, I suppose depending on the nature of the negotiation and the way that's going, if the tenant or landlord feels strongly that their contribution should be reflected in the rent, then yeah, the parties will have to hash that out. So it can be a factor.
Okay, perfect. Another question, if a landlord and tenant agree privately without legal consultation to new terms by way of memo of understanding or a side letter, has this a legal standing?
That's probably more of a legal question than a surveyor question. I would say it depends on what the implications are supposed to be for that. You're advised for a deed of renunciation to get legal advice before signing one. If the landlord and tenant come to a commercial agreement outside of that, in terms of it depends on what's contained within that lease and what's contained within that side letter, as to the relevancy of that question.
Perfect. Another question we have is fixed term when calculating any or always 5 years?
No, it's not always 5 years. It depends. It's a case by case basis. You could have a 10-year lease with a break in year 5 or 7, or whatever. So it depends on what the lease says.
Okay. There's another question in asking, can you describe the process of arbitration in detail?
I would like to think I've covered that in that slide there, but whoever asked that question, if they'd like to email me, I can or I can arrange to give them a bit more detail on that.
Perfect, brilliant. And then one last question for you, Ian, is how do you stay up to date with changes with the process of rent reviewing with legislations, and maybe market trends? How do you personally stay up to date with those changes?
Yeah, I mean, I suppose personally, I stay up to date because I'm constantly doing rent reviews, every day of the week. It's what I do. We're quite specialized in that sense. So new kind of arguments come up from time to from day to day in rent reviews. So I suppose it's just being clued into what's going on in the market, and keeping up to date with any any legislation that might come out or might be involved in the news, or that would be the usual way. It doesn't happen very often in terms of legislation changing, so when it does, you tend to hear about it. But otherwise, it's really about just keeping your ear to the ground in terms of what's going on in the market.
Perfect, brilliant. Now, there's one last question, so we might just go to it. The question is there any limit on the dilapidation claims?
That's probably not necessarily that's probably a question for a building surveyor first and foremost. So I don't know if there's limits to that. So you'll have to ask a building surveyor, unfortunately.
No problem. Brilliant. Well, thank you, Ian, for a fantastic presentation, and thank you everyone for joining today. The slides and the recording of this PQSL will be uploaded to the CPD library on the SCSI website in the coming days. Thank you, Ian, and thank you everyone for joining today's session.
Thank you.